The Kingdom of Kuba, home of about 75,000 Bantu speakers, is flanked by the Kasi, Sakuru, and the Lulua rivers in the former Kasi province of the Congo. Comprised of several chiefdoms, it is ruled by the centrally located Busham chieftain, whose bead is automatically the king of all the Kuba. The king and the chiefs hold their offices by the divine right and are the only persons who have the power over life and death. The Kuba do not use presidents or compare cases to deduce analogies. Their legal process is based on equity and the power of Kuba political authorities, the chiefs and the king. The following discussion of Kuba procedural law is by Dr. John Vansina, the author of this volume's chapter on Inner Africa and professor of history at the University of Wisconsin. The court ceremonial and formula he describes date back to about 1650 AD and were used until 1892, the beginning of the colonial era in Kuba land. Since then, there have been some minor changes, but on a local level, Kuba law remains as outlined in the following essay. A case is introduced by one of the disputing parties. He brings his complaint to any judge in the capital, who directs him to a competent judge. The party deposits a payment of 700 cowries for the formal lodging of the complaint. Through the informal consultation, the judge then forms a panel. In cases where a public authority has been flouted, the responsible political official, a village headman, for instance, lodges the complaint. When the day of hearing is set, usually a few days after reception of the complaint, the judges send somebody to notify the defendant. Now, the messenger may be the child of one of the judges or Naim Shabdi, a special messenger. The messengers must be well treated in the villages, for courts can hold villages in contempt. The courts of appeal have their own means of summoning the defendant. Ba'ang, the appeals court that oversees marriage cases, sends the Arel Wang Akim appeals court for debtors, and the Supreme Court have their summons announced on the main square of the capital by the town crier. Anybody who meets the accused is under obligation to notify him. When an accused person refuses to answer the summons, he is fined and arrested either by his co-villagers or by the slaves of the king or the chief, who form the police force. He is then bound and put in the stocks at the jail in the Kakim's compound. Now, the stocks are used only for preventative detention of this sort. Any person may arrest any other in flagrante delicto, a fact that often leads to fights. A wise man notifies the two village policemen who exits in every village. Before the session of the court opens, the accused pays 700 cowries to the panel, and the 1,400 cowries of both parties is divided among the judges. This amount constitutes their salary. Both parties, one after the other, then tell the facts, the plaintiff being the first speaker. At this stage, they may be interrupted only by judges or spectators who want to elucidate one or the other detail. Eyewitnesses or other character witnesses are then called in and are cross-examined by the judges, who also cross-examine the parties. Usually the statements of the parties and the testimony of the witnesses elicit the facts to the satisfaction of the judges. The latter in any event have a general knowledge of the facts, having heard about the matter through gossip at the capital or through inquiries made beforehand by the provincial chief. Sometimes, however, the facts are not clear and there are no witnesses. The accused may then propose to swear an oath in Doko. He says that he is innocent, invokes the Creator God as a witness, and steps over a leopard skin, the symbol of political authority. If he lies, he should die on the spot. But the oath is rarely used, for it is believed that the Creator punishes those who swear for trifles. I believe that the judges feel that swearing an oath is taking the matter out of court. A milder oath also exists, but it is considered no more than an emphatic form of speech. After the evidence is heard and the facts are elicited to the satisfaction of the judges, they withdraw to deliberate. They must reach a unanimous verdict. After doing so, they emerge and proceed with the announcement of the verdict, which is introduced by the following formula. The king doesn't walk with a bow. The collector of the conflicts, the verdicts of the cases. The black Jeanette eats the white termites. Be not afraid of the grass the Jeanette carries. The old animal of the counselors of the Supreme Court, when he proceeds to decide cases, he doesn't like protests. Above the thieves, the leopard of the witches, the spoon of the porch is the instrument which probes the depths of the fire. It dawns at the chasm which begets the hills, at the world which begets the living. The river of the trade bears the weak ones. It becomes daylight at Mekbe Botum, at Makum Imyange, at the king who stares intently at the verdicts, at Mbum called Mashum. The formula means the king is in the court to settle the conflicts. The king destroys the criminals. The innocents must not be afraid. The king in the Supreme Court does not stand for protest against the verdicts. Despite the thieves, the king can find the culprits. It dawns at the king who creates the world, who creates all living beings. The king protects the weak. It dawns at the famous capitals, at the king's capital when he holds his court. The formula is given in full because it is typical of Kuba thought. It emphasizes that the courts hold the authority from the king, and that the king has authority by virtue of divine kingship. It reminds the guilty parties that justice will find them out, and that the innocent parties that they are protected by the king. It reminds all that the verdict should not be questioned. It expresses the Kuba philosophy of law and stresses that fundamentally the law has equity. It is guaranteed by the powers of the king, but the equity of the king himself is guaranteed by the Supreme Court.